What if the contract for your next big brand or marketing deal was actually a monster and it just swallowed the rights to your best work? Sometimes what looks like a great influencer or marketing contract can hide a monstrous reality. Much like the eerie, compelling creatures from classic horror films, these contracts often have hidden claws in their clauses that can wound your business and intellectual property, or IP. I'm Julie King, a rock and horror loving patent attorney with over 25 years of experience as a lawyer, and in that time, I've seen too many businesses and creators lose control of their most valuable assets, their brand and their content, by overlooking a few critical legal clauses. In this episode, we're confronting the contract from the Black Lagoon. You'll learn the 3 essential legal traps in marketing, who truly owns the content, how to dodge crippling FTC fines, and how to protect your personal brand. I'm not here to be a stuffy lawyer throwing legal jargon at you. I'm here to break down complex U.S. legal issues into plain language so you can focus on creating killer content while keeping your legal defenses airtight. It's time to stop signing bad deals. Let's dive in and battle that contract creature and the traps it sets to ensnare your business and IP. Trap 1 is the Siren's copyright song, luring content owners astray. When a creator, influencer, or filmmaker produces a piece of content for a brand, such as a video, a custom song, a photo, or an edit, the key question is, who owns the finished work? The natural assumption is that often the person who paid for it, the brand, owns it, or that the person who created it, the influencer or marketing agency, owns it. The legal answer is far more specific and is rooted in U.S. copyright law. The law provides 2 main paths for a brand to obtain rights to content created by an independent contractor. The first is copyright assignment or licensing, which is transfer of ownership or permission to use. This is the most common way ownership of copyright rights is handled between a business and an influencer or marketing agency. That relationship is defined by those contract terms, and those terms include how copyright rights will be handled. Assignment is used when the creator initially owns the copyright, but then transfers all of the ownership rights to the brand in assigned writing, such as a clause in the contract. In marketing service deals, while the creator is still the author, the ownership of the work is assigned through the terms in the service contract to the business who contracted with the marketing agency to have the work done. A license is used when the creator keeps ownership of the content, but grants the other person or business permission to use it under specific conditions. In many influencer deals, the influencer is the default owner and the brand is granted a broad license through the service contract to use the work created by the influencer. The contract may also include restrictions on how the influencer can use the content they own in order to protect the reputation of the brand. The second main legal mechanism for dealing with copyright ownership is a work made for hire. This is less common because the rules are strict. There are 2 ways a copyrighted work can be a work made for hire, or work for hire as it's more commonly known. The first is through an employment agreement. When someone is in an employer-employee relationship and the work was created as part of the employee's regular duties, it's a work for hire, and the employer is legally the author and the owner. The employee has no rights to it. How do you know whether it's an employer-employee relationship? That, of course, depends on a bunch of things. It's too much detail to go into in this episode, but you can find that information in the very popular Circular 30 at copyright.gov. It's a good idea to consult a copyright lawyer about this. A labor or an employment lawyer will know the technical definition of an employee-employer relationship under state law. But copyright law looks at other issues to decide whether the creator is an employee or an independent contractor. If your business has a marketing department, the people in it are most likely employees. If you hire a marketing agency, the agency and its employees are almost never your employees. The second way something created can be a work for hire is when the work was ordered or commissioned by someone and it meets strict guidelines. For an independent contractor's work, or work from a marketing agency, to be legally considered a work made for hire, 3 things must be true. First, the parties must sign a written agreement. Second, the written agreement must explicitly say it is a work made for hire. And third, the work must fall into one of the 9 specific categories defined in the Copyright Act, such as a contribution to an audiovisual work or a compilation. You can look at that Circular 30 at copyright.gov to see what all 9 of those categories are. If any of those requirements are missed, the work is not a work made for hire and the creator is still the author and the ownership is decided by the contract. Let's look at the horror story of overreaching licenses and unintended assignments. The true horror happens when a contract is poorly drafted or poorly understood. For instance, an influencer thinks they're giving the brand permission to use a short TikTok video for 1 month, but the contract grants a perpetual, royalty-free, worldwide license to use the content in any medium now known or later devised. That creator has effectively given the brand permission to use that short clip forever, in any context, print ads or television or any other context or medium, without paying the creator another dime. Or consider a contract in which a business hires a marketing agency, but that doesn't have anything in the contract about assigning copyright ownership to the business. That means the business might not own its own marketing material, and the agency may remain the owner. You can see how that could end up being a huge problem and lead to expensive legal battles over who really owns the material and who can use, change, or sell it. Would you want material made for your business to use also sold to some other business with just a few minor changes? Now we'll look at Trap 2, which is the Leviathan Grip of the FTC's rules about transparency and disclosures for influencer marketing. This trap for the unwary is more about consumer protection than about intellectual property, but it still touches on the truth behind the content. Like with intellectual property issues, the consequences of getting the legal details about transparency and disclosure wrong can be terrifying. In this case, they can include fines, class action lawsuits, and the destruction of consumer trust. The Federal Trade Commission, or FTC, enforces the law that prohibits unfair and deceptive acts or practices, which includes misleading advertising. The rule is simple. If there is a material connection between the brand and the endorser or the influencer, that connection must be clearly and conspicuously shown. A material connection is anything that might affect the weight or credibility of the endorsement: cash, free product, loans, or a family relationship. By law, it is permissible to pay an influencer to endorse your product. However, it is legally required to show that paid relationship. While some platforms have built-in disclosure tools, those aren't always sufficient. The FTC's focus is on whether the disclosure is clear and conspicuous. Hiding the disclosure behind a see more link, burying it in a block of 30 other hashtags, or using ambiguous terms like hashtag collab or hashtag partner are legal mistakes that, whether they were made on purpose or accidentally, are considered a deceptive act under the law. The FTC doesn't care if you didn't know the law. Here's a case example. The FTC has taken law enforcement actions against brands like Lord & Taylor and the American Beverage Association and their influencers for non-disclosure. Class action lawsuits filed just this year against major brands such as Shein and Celsius and their influencers show that private plaintiffs are also targeting these issues, seeking massive damages if non-disclosure is proven to have misled consumers. Here's a key takeaway for both brands and creators. Always make sure your disclosure is unambiguous and impossible to miss. Use clear terms like hashtag ad or hashtag sponsored at the very top of the caption, or superimpose clearly on a video. Now we'll swim on to Trap 3, protecting your brand, name, likeness, and voice from the reputational whirlpool. The creator's greatest asset, often more valuable than any single video, is their personal brand, their name, voice, signature look, and unique style. This is protected by the overlapping areas of trademark law and the right of publicity. A trademark protects your brand source and identity. For example, your podcast title, your logo, or your unique clothing line name. Even if you haven't registered the trademark with the USPTO or your state, you do have some common law trademark rights. They're just pretty weak. Registration with the USPTO, when it's possible, and it's not always possible, gives you the most enforcement rights and the ability to maximize a judgment against an infringer. The right of publicity is a state-based right that gives every person, especially celebrities and influencers, the right to control the commercial use of their name, likeness, image, voice, and other identifying characteristics. Now, it doesn't usually provide any protection for news, parodies, or public interest use. Since it is dependent on state laws, the exact rights vary from state to state. Here's the contract trap here. If an influencer contract is too broad, it might grant the brand rights that undermine the influencer's own brand. For example, the contract might allow the brand to exclusively edit the content in a way that damages the influencer's reputation, or give the brand the right to use the influencer's name or likeness in unrelated future marketing materials without a separate fee or review by the influencer. An influencer successfully suing a brand specifically for misappropriating the influencer's own trademarked catchphrase or brand name and passing it off as their own is still an evolving area. However, there is an ongoing dispute between social media influencers Sydney Nicole Gifford and Alicia Shield that shows influencers need to think seriously about their own trademarks and about infringement. In this case, dubbed by some as the sad beige lawsuit or the vibes case, Gifford, who curates a distinct minimalist, neutral beige and cream aesthetic, kind of the opposite of my aesthetic, for her content and her Amazon storefronts, sued Shield for copyright and trade dress infringement, alleging that Shield copied her specific aesthetic branding, styling, and content structure closely enough to confuse followers and dilute the distinctiveness of Gifford's brand. While people often think that trademark law just covers words and symbols, trademark law also protects trade dress, which is about the overall commercial image or total look of a product or service. The classic Coca-Cola bottle shape is a great example of trade dress. This case underscores that for creative entrepreneurs, the unique aesthetic of the brand is a critical asset that must be protected, often requiring registration of copyrights and trademarks and the strategic use of trade dress law. Now let's step right up to learn a horror story of a violation of the right of publicity. The right of publicity is why, for instance, Tom Waits successfully sued Frito-Lay and its advertising agency Tracy Locke Incorporated for using a singer whose voice sounded exactly like his in a commercial for Salsa Rio Doritos, and with music that strongly evoked Waits' Step Right Up, perhaps one of his best-known songs. Waits famously refused to do any endorsements and spoke out against celebrity endorsements, saying they cheapened their image. Frito-Lay and the advertising agency hired Stephen Carter, a musician known for his spot-on Waits impersonation, to do the singing. The musical director for the ad even suggested the singer was too spot-on and that could land them in legal trouble, but he was unwisely overruled. Waits sued and won $375,000 in compensatory damages and an extra $2 million in punitive damages, which are damages meant to punish the loser for bad behavior. The appellate judges noted that this kind of unlawful violation of the right of publicity is really an invasion of personal rights, and they quoted a previous decision involving Bette Midler against Ford Motor Company, saying, quote, "What is put forward as protectable here is more personal than any work of authorship. A voice is as distinctive and personal as a face," end quote. It's worth noting that the court rejected the argument that if the person whose identity is misappropriated isn't well known enough, then the misappropriation didn't really matter. The kicker is that the appellate court noted that in Step Right Up, quote, "Waits characterizes the song as an indictment of advertising. It ends with the line, quote, 'What the large print giveth, the small print taketh away,' end quote." Now we have breaking news. Coca-Cola was just sued over their attempt to cash in on Johnny Cash's vocal style with an imposter. Just last week, on November 25th, 2025, as I was writing this material, news broke that the John R. Cash Revocable Trust filed a lawsuit against the Coca-Cola Company regarding the right of publicity and Tennessee's new ELVIS Act, among other laws. Johnny Cash has one of the most legendary and distinctive voices in music history, one that's readily identifiable even to casual listeners. The trust, which owns the commercial rights to his voice and likeness, sued Coca-Cola over a 2025 college football advertisement campaign. The complaint alleges that Coca-Cola hired a Johnny Cash tribute singer, what they called a sound-alike singer, to record a song for the ad. Now, the singer is a known Cash tribute performer. His own website calls him the #1 Johnny Cash tribute show. And that makes the similarity to the Waits case stronger. The complaint alleges the purpose was specifically to ensure the ad sounded as close as possible to Cash's voice, and it alleges consumers were actually confused, believing it was a new track by the man in black himself. The trust alleges that Coca-Cola, despite its long history of licensing celebrity endorsements, which shows it knows these licenses are necessary, failed to even ask the trust for a license or permission to use someone who sounded like Cash. The lawsuit asserts Coca-Cola violated the ELVIS Act, the Tennessee Consumer Protection Act, and the Lanham Act, underscoring the legal recognition that stealing an artist's voice is theft of their integrity and identity. Now, you'd think marketing firms would have learned from the Tom Waits v. Frito-Lay and Bette Midler v. Ford cases, but clearly not. I don't think Coca-Cola and the advertising agency that will inevitably be dragged into the lawsuit will enjoy the penalties under Tennessee's new ELVIS Act and the other acts cited, but ironically, it may be the publicity they enjoy even less. Now let's look at the deepfake end of the lagoon, the unauthorized use of artificial intelligence, or AI, to clone or duplicate a celebrity's likeness, particularly their voice or image, often called a deepfake or digital replica, has led to a rapid but fragmented legal response. Because no single federal statute directly addresses this issue yet, the legal battle is being fought primarily under state-level right of publicity laws. Tennessee, home to many entertainers, enacted that wonderfully named ELVIS Act, which is short for the Ensuring Likeness, Voice, and Image Security Act, which updated its right of publicity law to protect an individual's voice from unauthorized AI simulation. Similarly, California has passed new legislation aimed at protecting digital likenesses of performers. Federally, legislation like the proposed No Fakes Act has been introduced in Congress to create a national harmonized federal right of publicity that specifically covers digital replicas, but such efforts face complex challenges, including balancing creator protection against First Amendment free speech concerns. In the courts, claims often combine state right of publicity laws with federal Lanham Act claims for false endorsement or passing off, and breach of contract, highlighting that for now, the strongest protections are found in state statutes and precisely drafted contracts. Here's a key takeaway for creators. Do not let a contract give the brand the power to tarnish the goodwill you've built into your personal brand. Ensure any use of your name, likeness, or voice is strictly limited to the agreed-upon campaign and that your right to protect your reputation is preserved. Make sure there are explicit provisions about the use of AI to replicate your image, voice, etc. Now, you don't have to face the contract from the Black Lagoon and its slimy pals alone. Navigating brand partnerships doesn't have to be terrifying. If you're a small business or hiring a marketing team or agency or using influencer marketing, or if you're a creative entrepreneur signing your first or your 20th brand deal, remember this. The horror contracts are usually the ones you sign without having a thorough review. Having an attorney review these clauses, specifically the IP ownership, disclosure, indemnity, and right of publicity sections, is an investment that protects the commercial value of everything you've worked hard to create and makes it clear who has the rights to what going forward. Whether you're the creator or the brand, it's important to spend the time and money to make sure the contracts give you the proper protection, because the contracts are often the only thing standing between a profitable collaboration and a legal nightmare. Intellectual property is one of the most terrifyingly useful tools you have. If you're ready to build a frighteningly powerful brand and business, you need to know how to use it. Don't face the darkness alone. To learn more about protecting your creations, your name, your business, and your legacy, you can book a consultation with me at kingpatentlaw.com. I'm Julie King, a licensed attorney helping entrepreneurs across the U.S. make smart, legally sound decisions about their intellectual property. If this episode helped you survive the horror of learning about how to protect and manage your intellectual property and business, please like and subscribe. Find all my other frighteningly good content on my website, at Spellbinding IP on all major podcast platforms, and at King Patent Law on social media. Remember, the information here is for educational purposes only and does not constitute legal advice or form an attorney-client relationship. Always seek the counsel of a licensed attorney, perhaps me, for your specific legal needs. Thank you for tuning in. Stay legally sharp and keep rocking your IP.